Good morning, everyone, and welcome to the Supreme Court. We have two matters on today's agenda. The first one is Kelly Services versus Senior Network. Each side will have 30 minutes to argue. The appellant may reserve any portion of their time for rebuttal. Senior Associate Justice McDonald will be our timekeeper. He will let you know when there is 5 minutes, 3 minutes, and then your time is up on your main argument. I'm assuming that everyone's read the memo concerning virtual hearings. Thank you very much. So if you're ready to go forward, counsel for the appellant, if you please identify yourself for the record and let me know how much time, if any, that you wish to reserve for rebuttal.
Your Honor, James Nealon from Withersbergman LLP, counsel for defendant appellant, the Senior Network. If I could reserve 10 minutes for rebuttal.
Thank you, counsel. You have your 10 minutes. I just want to remind everyone, if you are not actually speaking, please mute your microphone. That keeps the noise level down. I greatly appreciate that. Whenever you're ready.
Sure. I'm ready to proceed. Thank you, Your Honor. So I think, as I understand the issue presented to this court by the trial court's opinion here is, does a trial court judge in Connecticut have the authority under Section 52192A to award what amounts to a post-judgment rate of interest higher than 10%? My reading of Judge Karazin's decision was that he was essentially saying the 8% post-judgment interest rate and pre-judgment interest rate would run. And also after the judgment, there would be an additional 8% that would run, 16% concurrently. And I would argue to this court that that's not supported by the express statutory language of 52192A. And in particular, focusing on Section C, the language says the court shall add to the amount so recovered 8% annual interest on that amount. So
There's a question from Justice Ecker.
Thank you. Mr. Nealon, can you hear me?
I can, Your Honor.
Okay, great. I just want to make sure. I can't see you, so forgive me if I don't read your body language right or something like that. I'm just kind of transmitting into the blind right now. I apologize for that. So it just happens sometimes with our system. So I just want to clear up in my mind what I think we're on the same wavelength, but what the issue is before the court and what's not before the court. The only question before the court at this point is the offer of compromise interest running from the date of judgment forward, right?
That's correct, Your Honor.
Okay. I'm just trying to, so has any amount of the judgment been paid? I mean, normally what happens in these appeals where there's an interest dispute is the defendant.
I saw that Attorney Neal said something, but I didn't hear him.
He was muted.
I'm sorry, I was reading somebody else's head shake. So
I still can't.
Your Honor, none of the judgment has been paid.
Okay, I'm sorry for interrupting. So that's odd to me, because normally what happens in these cases is that the undisputed portion of the judgment is paid. The reason for that is obvious. You stop the interest clock running. So what I don't understand, and this may not be a legal question, it may be a practical question, but as I calculate, I mean, if you folks had paid, the undisputed amount of the judgment is what? Is something like $177,000 due as of December 2nd, 2019?
Your Honor, the principal amount of the judgment is approximately $114,000, and then there's the prejudgment interest that was added on top of that at 8%, under the regular prejudgment interest statute, and then an additional amount for offer of judgment.
Right, and that adds up to $177,280.80, right?
Right. It has not been paid, and the plaintiffs have not requested payment.
Well, I'm not sure they have to. I mean, they're happy getting they're either getting 8% interest on that amount or 16% interest on that amount, but I wouldn't ask for it to be paid either, because 8% is a pretty good rate of return. My question is, I mean, I guess I'll put it this way. If you had paid that undisputed amount on or about December 2nd, 2019, we wouldn't be here, would we?
Well, we wouldn't be, Your Honor. I think this is a case where, factually speaking, without getting into the details, there's going to be some question as to my client's ability to pay the $177,000.
Okay. Because I would point out, sir, that even if you're right on the merits, for every dollar that you win by a successful appeal here, you lose $1 under 37(3)(a) for post-judgment interest. They're earning 8% on the judgment, so they get a buck, 8% on that $177,280 for every day that goes by. And even if they lose that same amount, because you're right on the appeal, anyway, it just seems like as a practical matter, unless they're judgment proof, the game isn't worth the candle. But I guess that's a strategy call up to you. The legal question is presented. So if you don't have anything further to say on my sort of practical analysis, go ahead with your legal.
Yeah, just real quick on the practicality. I'm not so sure I would go so far as to say judgment proof, but I think there's a serious question whether there's an ability to pay the whole judgment and at what time period my client might be able to pay that in the future. Should there be
but you do understand 8% is running under the uncontested portion of the judgment, right?
I absolutely agree that's the case. Yes.
Okay, go ahead, sir. I've taken long enough.
Not a problem.
Counsel, there's a question from Justice Keller.
Is there another question?
Yes, thank you, Chief. Good morning, Mr. Nealon. I have two questions. Number one, is Kelly Services what used to be known as Kelly Girls? Is that correct? Is this temporary workers being provided by the plaintiff to your client?
Yes, Your Honor. Kelly Services, I believe, is one of the largest temporary.
What is the Senior Network, Inc.? What does it do specifically?
The Senior Network, Inc. works with pharmaceutical companies and other companies to provide clinical testing for drug pharmaceuticals, any kind of situation where you need to recruit people to participate in polling, those type of activities. So in this particular case, as far as the underlying merits, my client was involved in a project where they were working at Walmarts all across the country to basically present Medicare services. So they needed temporary workers to fill that assignment.
Is it a nonprofit or a profit?
It's a for-profit company.
It's a for-profit company.
Yeah.
All right. I looked at Gianfrido, and I think Gianfrido makes it pretty clear to me, and I don't know if it just matters whether or not this is a negligence case, that the compromise of the offer of compromise interest is prejudgment only. Is that the way you read it?
Yes, Your Honor. I read it that what should basically happen in all of these cases is at the time of judgment, a person who fails to meet the offer and unreasonably delays the settlement of a case, that the trial court judge will then go back to the applicable date, calculate what that amount is as a sum certain, add it to the judgment, and then the defendant who didn't pay it would then have to pay potentially post-judgment interest on the entire judgment, inclusive of the offer of judgment and any prejudgment interest amount.
And then I looked at Delito, and Delito doesn't really refer to the issue of 52-192A interest as prejudgment interest. All Delito said, and this is the Delito that is in volume 310 of the Supreme Court reports, is that Gianfrido never addressed whether getting some prejudgment interest makes you unentitled to mandatory post-judgment interest. And that's not our issue here, is it? Because you admit that the post-judgment interest keeps running, correct?
Yeah, the post-judgment interest here is at 8%, or even if it had been 10%, would have been entirely appropriate.
And Delito refers to 52-192A interest as prejudgment interest, does it not?
Correct.
All right. Thank you, sir.
Yeah. So it's our position that there's nothing in the statutory language that expressly states, suggests, or otherwise implies that at the time of entering judgment, a trial court in Connecticut should apply additional post-judgment interest, above 8-10% or whatever the typical mandatory amount is. And if that were the rule, I think it would cause, quite a bit of issues, which I'll get into in a minute. And actually, when I read Judge Karasin's initial memorandum of decision, I had to read it a couple of times, thinking, am I reading this wrong? So I did file a motion to re-argue and/or for articulation, thinking that maybe the language, I was just misreading it. But my ultimate takeaway was that, in fact, Judge Karasin did intend the additional penalty interest to apply until this judgment was paid. So in addition to the plain language, I think the position of this trial court, and of the appellees here, is contrary also to the practical construction of 52192A by the trial courts in Connecticut over the course of this statute's history. And in fact, the cases that we cite in our brief, I think are all consistent with the way I described how it should work. And indeed, in the George's case, which Your Honors decided in 2020, although the core issue there was not how you calculate, the offer of judgment interest and when it terminates, it's clear from looking at the appendix from the appellate court's decision that that's exactly how it was calculated. That the trial court, at the time that it assessed the offer of judgment interest, calculated a fixed sum and added it to the judgment.
Counsel, I've been waiting for a logical break point. Sorry to interrupt you.
Sure.
Justice McDonald has a question.
It's just very brief. In your research, have you found any Superior Court judge who has shared Judge Karasin's interpretation of the statute?
I have not, Your Honor.
Thank you.
And then from a policy point of view, if this was actually an alternative way or the correct way to do it, I think it opens up a can of worms as a practical matter, as to how offer of judgment interest would be assessed in the future. Would a trial court, if this court were to agree with the plaintiff's position in this case, what would the standard be? Would a lump sum, still be calculated? And under what circumstance would the trial court exercise discretion, if it's even permitted to exercise discretion, to have offer of judgment interest continue to run post-judgment? And in some of the Supreme Court's prior opinions on this, this court made it very clear that, at least from a pre-judgment point of view, offer of judgment interest is mandatory. There is no discretion involved. So that would be another issue that would seem to need to be sorted here. And also the way Judge Karasin in this particular case wrote up his memorandum of decision, if trial courts were to say, okay, it's going to be 8%, between this date and then another 8% post-judgment, without putting in the sum certain calculation, it's going to get very confusing in cases where the judgment is not simply paid right off the bat, such as this case. 5 years down the road, 3 years down the road, it would seem to open up a lot of possibilities for disagreements as to, well, what is the proper amount of the judgment? And how do all those interests come together? So I think the other thing is this is a punitive statute, but it's meant to perform a useful purpose, which is encouraging early settlement of cases. So if the goal of the statute is to try to induce early pretrial settlements, I think the question then arises, if we have a world where you can get additional offer of judgment interest or offer of compromise interest after the judgment, well, what purpose does that serve? Because what you could effectively have in a case where there's already 10% post-judgment interest is an 18% post-judgment interest rate, which means the judgment will double, every 4 years, that is a fairly draconian circumstance, it seems to me. And not that judgments shouldn't be paid, because obviously they should, but is that really needed, and is that what the legislature intended? I think the statute should be given, if there's any doubt here, should be given a narrow reading.
Counsel, there's a question from Justice Ecker.
Sure.
Yeah, just on that point, I mean, in a way, it argues against you, I suppose. I think, I mean, it strikes me your best argument is that this issue has been decided, but under the case law. But from a policy point of view, you could easily see a legislature or a court interpreting a statute say, look, I mean, the plaintiff gets, well, right now, 16% prejudgment interest.
Right.
In fact, they get more than that because it's compounded. In other words, they get the offer of judgment interest on the aggregate of the debt due plus the 8% prejudgment interest. So they get 16% prejudgment. And, you could easily see the logic of saying, look, the penalty continues post-judgment. It's about continuing this exact same logic of the offer of compromise statute, which is that if you don't settle early, you're going to pay later. And so there's no necessarily policy or logic-based reason to cut it off at the date of judgment. That was based on statutory interpretation, as I understand it, right?
Yeah, look, I think the strongest argument, I agree, Your Honor, at least in significant part, the strongest argument is the express language of the statute doesn't call for this. And the cases that have been decided to date, I think, support the position that we're taking pretty clearly, both at the Supreme Court, the appellate court, and even at the trial court level. So, if now the question is, should there be a departure from that, I think the best course is to read the statute narrowly and leave that type of change up to the legislature, if it's going to be made, consistent with the prior rulings.
Thank you. You've answered my question.
Okay.
Thank you.
Yeah, so I think I'll
Counsel?
stop here and reserve the rest of my time unless there's any further questions from any of the justices.
Counsel, there is another question.
Sure.
One thing I forgot to say in the beginning of argument is that the justice will either raise their hand or their virtual hand. So if you see the little yellow hand, if you would pause your argument at the next logical stop point, I'd appreciate it. Justice Keller.
Attorney Nealon, what's the usury rate in Connecticut right now? I'm sorry, you're muted, sir.
I believe it's 12%, Your Honor.
12%. Okay. So even if he could award this post-judgment offer of compromise interest, can't we look at this case as to whether or not there's an abuse of discretion here? I mean, first of all, the 37A3 interest rate is very high, and it's been high for years, given the rate of return you could get on any kind of investment. And could we look at this 16% award if it's correct? In the view it as, I think the standard is abuse of discretion on interest awards. Could we also look at it that way as an alternative?
I suppose, I wouldn't disagree with that. It's not what I argued. I think my position is more just based on the express statutory language, how the statute has been applied by the appellate courts and trial courts in Connecticut. I think that is a, perhaps cleaner way to approach it because you don't have to get into the facts of each case. But I think your question kind of comes back to an earlier point that I made, which is, if this is something that's theoretically possible, well, how would that discretion actually be exercised, right? Because under the prejudgment section, there is no discretion under 52192A. So I guess that was my point in saying it kind of opens up a can of worms. I mean, this particular case is not a large, dollar case. And frankly, I didn't spend a lot of time when we filed the notice of appeal, taking it that far. But it would be another way, I would agree, to analyze this.
All right, thank you.
Thank you.
Thank you, counsel. You have your remaining time. Attorney Clark, are you ready to proceed?
Yes, Your Honor. Again, Robert Clark for Kelly Services. To start off, just to address the last question from Justice Keller, this is an abuse of discretion standard. And I would assert that there has never been any case that specifically was requested to address the only issue that's before this court today. I fully acknowledge Your Honor's question or maybe statement to Mr. Nealon about Gianfrido, and I would be disingenuous if I stood up here or was before this court and said that it wasn't addressed in dicta, but I think it was just that, it was dicta. And if you look at Gianfrido and the issues that were before the court in that case, the only issue that was going to be addressed by this court in that case was whether the plaintiff was entitled to offer of compromise interest in general. Indeed, the trial court had denied the motion for interest, and the plaintiff had appealed. And there was an additional issue in that case as to whether it was necessary to compare the offer of compromise to the judgment amount, especially in a circumstance involving treble damages. And those issues are not before this court, are not relevant to the instant appeal. And instead, I see there's a question. I can stop.
Yes, counsel. There are questions from Justice McDonald and Justice Daria.
Right.
Counsel, if Judge Karazin misinterpreted or misapplied the statute, that's not an abuse of discretion standard, is it?
I think, my interpretation and reading of the case law is that any question regarding interest is to be reviewed for an abuse of discretion. And Judge Karazin's memorandum was based on the statute.
Well, the rate to pick is discretionary, but if it's not allowed, if the statute doesn't permit this, then that's not an abuse of discretion standard. That's plenary, isn't it?
I would agree with that, Your Honor.
Okay. What do we do with the fact that the legislature in 2005 changed this structure from being an offer of judgment at 12% and lowered it to 8%, given the fact that the testimony around the time was that the rate was too high for offers of judgment, now offers of compromise? What do we do with that background information in the context of this to inform when offer of compromise interest was supposed to end?
Well, I mean, I think that kind of piggybacks on Justice Ecker's prior question that to Mr. Nealon, that if the offer of compromise interest is permitted to run until the judgment is satisfied, we're really just keeping consistent the pre and post judgment interest. And I think that's fully equitable and fair. There's that you'd have an expectation that you'd be subject to a better interest rate when you have a judgment against you than you would for pre-judgment. I don't necessarily see the logic in that.
My final question is the same one I asked your opposing counsel. Has any other Superior Court judge ever interpreted 52192A in the manner that Judge Karazin did in this case?
If they are, I'm not aware of it.
Thank you.
That's the best that I can give you.
Thank you.
Thank you, counsel. Justice Daria, then Justice Keller.
Thank you, Chief. Attorney Clark, did you, I don't know if there was I'm not exactly sure how this came up. Did the judge in his memorandum of decision just issue the order? I think that's how I read it. Did you ask for this interest rate to run pre-judgment and then post-judgment, or did you just get it and you're defending it?
So, Your Honor, what I mean, I guess it's probably appropriate to go into a little bit background because there have been questions about the background of the case, and so I'll give you maybe a longer answer to that than necessary, but it might be helpful. So this matter, obviously, we filed an offer of compromise years ago, back in 2018. Obviously, there was no response to that. The case proceeded to a bench trial, and following the bench trials, when we submitted proposed findings of fact and conclusions of law. At that point, no, there was no request for specific judgments or specific interests from either party. And subsequent to that, Judge Karazin issued his memorandum of decision regarding his findings of fact and conclusion of law. In that decision is when Judge Karazin came up with the interest rates that were going to be applied,
and the length of
and the length.
One not merging into the other. So okay, sure. I get it. Thank you.
That's where this all began, and then as Mr. Nealon correctly indicated, the senior network filed a motion to re-argue. I did file a response to that just for purposes of completeness, and in that I did argue for it. So it's not like I've never argued for it.
No, I'm not suggesting it's not a preserved argument. I'm just wondering how it came up. Okay, thank you.
The genesis of it was Judge Karazin.
Gotcha.
Justice Keller.
Thank you, Chief. I just want to get this clear in my mind. The post-judgment interest that is running on the judgment, does that include the amount added to the judgment as the pre-judgment offer of compromise interest?
Quite honestly, Your Honor, that was not specific.
Because the 37A3 says you have to pay interest when you withhold money, that you shouldn't. When you should have paid something and you withhold it, whether it's intentional or not, you have to pay interest on the sum that was owed. But do you think it's fair that in addition to that, you'd have to pay interest on the sum that was owed as post-judgment interest, not as 52192A interest, with the offer of compromise interest added to it? Because that's not really something you were obligated to pay until judgment entered.
Right. I fully recognize that issue. And it may be an equitable situation where it should not be what has been already added to the judgment.
In other words, there should be 8%. What is the post-judgment interest award? I think it was 8%. That should be paid on the amount of the debt that was found due and owing as post-judgment interest. And then there should be the 8% he ordered on the offer of compromise should only be calculated based on the amount of the sum that was the offer of compromise sum from the date of the offer of compromise to the date of judgment. Does that make sense to you?
That makes complete sense to me, Your Honor, because I think that's consistent with the purpose of the statute, and that's what I was going to address next. I can't emphasize enough that this court has repeatedly indicated that this is a punitive statute, and it's meant to punish parties that do not accept the offer of compromise and then do not obtain a more successful or a better result at trial. And so to follow up on your question, Justice Keller, I think that a party that is presented with an offer of compromise is one in the best position to recognize the consequences of rejecting that offer, and it would be fully expected that if they did not do better at trial, that they would be subject to that offer of compromise or the verdict amount, for that matter, paying post-judgment interest based on that offer of compromise. And Mr. Nealon did indicate that the offer of compromise is intended to encourage pretrial settlements, and I believe that allowing for offer of compromise judgment or interest to continue to accrue until a judgment is paid that furthers that intention, that if a party realizes and has a full expectation that in the event they are not going to, in the event they reject the offer of compromise, they're going to have to pay that until the judgment is paid, there will be more incentive for some strong and serious consideration as to whether the party should accept the offer of compromise, especially in a case such as this, where there's an outstanding debt. Granted, the facts of that debt are not truly before this court, but in this case, there was express communications from the senior network to Kelly fully acknowledging that they owed this debt. And it's been our position all along, and it was obviously accepted by Judge Karazan in his findings of fact and conclusion of law, that the senior network had no reason not to pay this debt. And so, and that was part and parcel of Judge Karazan's memorandum. Is he said, or he wrote, look, this is also an equitable issue, that the senior network had been notified of their debt and acknowledged their debt in 2015. They were provided that as the first opportunity to pay the debt. The second opportunity, they were kind of given a do-over, if you will, in 2018 when the offer of compromise was submitted, and they still did not pay. So I think Judge Karazan was correct in that what is the policy of Connecticut? Is it one in which it allows a party to continue to shirk their obligations and their debt, or does it need to be more punitive in nature when you have had multiple opportunities and continue to fail to pay that debt? And there, again, going back to the precedent of this court, there is in the case law, it's specifically addressed that the offer of compromise is intended to penalize a party. And I would assert that by the same logic, the policy has to be that it is to encourage a satisfaction of judgments. Justice Ecker, I think that was part of your line of questioning to Mr. Nealon, that this really could all be avoided and can always be avoided.
Can I just say that a lot of people can't pay the whole debt that they owe. And they might be looking at a settlement that says, can I pay it off in installments? And especially less flush or less, parties without a lot of money. And in terms of encouraging that kind of settlement, I'm not sure that this policy-wise encourages that kind of settlement at all, because if I'm the plaintiff, I'll just put in an offer of compromise for the full amount owed and not settle for any installment payments and get my judgment after a bench trial. And then I'm going to add all kinds of money to what could have been reasonably settled as a possible agreement to pay an installment. So I'm not sure that this is what happened here is some kind of great policy result. Thank you.
Your Honor, there's obviously numerous practical considerations, right? I mean, at least in my client's perspective, they were always entertaining settlement, but there was never, that opportunity. And I think that you have to consider that, a party that may have reason to believe that another party is not going to be able to pay the full debt. I mean, what are they better off settling for some amount of that, or are they truly better off, kind of sticking it to the other party, if you will, and insisting on all this post-judgment interest if they really aren't going to ever get that in the long run? What is the best business consideration? And I would assert that, it's best to get whatever you can get, rather, a money judgment that has no teeth and is never going to be paid. I guess, I'm
then
not.
Why was your offer of compromise for the full amount of the debt and not a portion of the debt?
In this case?
Was your offer of compromise for the full amount of the debt owed or a portion of it?
It was for an already agreed upon compromise of an initial debt.
Okay.
That the senior network agreed following a kind of a period of time after this contract was complete as to what would be agreed upon, and there was no consideration or even reason for my client to believe that the senior network was not going to be able to pay the judgment, considering that the underlying contract was for over $1 million, which they had with another contractor who had a contract with the Walmart. So there was a lot of money at issue in this case, and there never was a reason prior to or up until the offer of compromise to believe that the senior network was not going to be able to satisfy that.
All right.
So I would just again emphasize that, look, the legislature could have included in the statute that the interest rate runs up until the time of the judgment. They did not. Obviously, this court has explicitly addressed numerous cases involving statutory construction and held that if the legislature intends to include something in the statute, they have the opportunity and the means to do so, and that we do not write into the statute things that could have and should have been written into it. And as I indicated previously, none of the cases, including the Georgia's case from 2020 that this court addressed, specifically addressed the issue before today. And in light of the policy considerations and the statutory construction arguments, I believe that Judge Karazan was correct. I see there's a question from Justice Eckert.
Thank you, Mr. Clark. Counsel, you'd agree that if Gianfrido, if the language in Gianfrido was not dicta, then you lose, right?
Absolutely, Judge.
Okay.
I'm not going to contend with that. I would contend that it was dicta and that it was inconsistent or improper, but I'm fully aware of the language in Gianfrido.
Right. No, and I get it. You're making your argument, but I just wanted to be clear on that. Thanks.
And if there are no other questions, I'll be done.
Thank you, counsel. Attorney Nealon. You're muted, sir. Attorney Nealon, your microphone is muted. It's still muted. We don't have the ability to unmute from this end.
Can you hear me now?
Yes, sir. Thank you.
Sorry about that. I'll try to be.
But I can't see you though. Half your face is cut off.
I'll try to be relatively brief in responding. So what I was starting to say is I think in terms of the standard of review, this is clearly a question of law. It involves the interpretation of a statute. So I don't think it's a question of discretion. Although I think some of the comments that Mr. Clark were making, actually would indicate the difficulty, the practical difficulty, if this court were ever to go down the road of accepting the plaintiff's arguments. The offer of compromise statute is, we have particular facts in this case, but it applies to all different stripes and types of cases. And its purpose, again, is to promote and incentivize early pretrial settlements to save the court's time, to save the party's time. And it actually, for practicing lawyers, has proven to be very effective at that. The issues that were raised by Mr. Clark seem to be focused on, well, we need to encourage people to pay their judgments. That's not the purpose of the offer of compromise statute. It's not its intent. And there is a post-judgment interest rate, which the legislature could put at 10%, it could put at 20%, I suppose it could put at 25%, right? There are a number of different ways to encourage and coerce defendants who either don't want to pay, can't pay, or can't pay right away to do this, but to use the offer of compromise statute for that purpose, it's not necessary and it doesn't fit with the statute. So I think that's my big point. I think the case law is clear. I think the practical construction of this statute on the ground has been to do it differently than Judge Karazin purported to do in this case. And I think that that should continue to be the way it is applied. Now, conceitedly, the face of the statute, and I've seen this in some of the Supreme Court and appellate court decisions, occasionally you'll see a line, 52192A doesn't explicitly say when it ends, right? But all the cases and the way it's been calculated and put into judgments, indicates that it ends when it gets calculated. That's the end of it, and that's the way it should be. So that's all I have, but I'm certainly open to any questions any of the justices have.
Thank you very much, counsel. Seeing none, I will call the recess until the next case, which will occur at 11 o'clock. As to the justices, I think the link may be active. Why don't we go into the virtual conference room for a few minutes? Thank you very much.